Namaskar and welcome to StudyIQ. I am your friend Rahul Saigaonker. The agenda for today's discussion is to understand legal perspectives surrounding personality rights. Why are we discussing this? Because recently the Delhi High Court has passed an order protecting the personality rights of famous actor Anil Kapoor. In this video lecture, we will understand the legal nuances connected with the concept of personality rights. What are personality rights? Are they defined in any law or statute in India, or is it just the judiciary at the rescue of these personalities? We'll understand all these things, right? Let's begin. But before that, there is a small notice for all the UPSC civil services aspirants. StudyIQ September batch of P2I Prelims to interview, it is closing out at the end of the month, and this would be one of the last opportunities to join the most comprehensive program for UPSC civil services preparation. In fact, this would be one of the last opportunities for preparation of 2024. So do not delay your decision. Just visit our website studyiq.com. You'll get all the information there. Go through the experiences of the students who are learning from StudyIQ, how they are improving their MCQ abilities and answer writing abilities, and join as soon as possible. I'll see you in the class. All right, let's begin. Recently, the Delhi High Court has passed an interim order where it has protected the personality rights of Bollywood actor Anil Kapoor. The judgment basically restrains other entities from misusing the name of the actor, the image of the actor, the voice, or other elements of his persona for their own personal gain without his consent. And I hope that I'll not be sued for using this image, Anil Kapoor's image. Now, nobody can use personality rights or personality traits of Anil Kapoor without his consent for their monetary gains. Now, you do understand there are so many trademark dialogues or trademark stuff which are connected with Anil Kapoor. One of that is the Jackass dialogue, yes, and then he has played some very renowned roles. For instance, the role of Lakhan, etc. Such things now cannot be used without the consent of actor Anil Kapoor. Now, that's the basic idea. So we'll try to understand what are the rights of these celebrities or rights of these personalities. Any celebrity or any personality has set of rights which they can defend. Without their consent, people cannot misuse them. And these rights can be broadly classified into two categories. One is the publicity rights. Again, you do understand the publicity rights are already covered, I would say, under the tortious liability or the law of torts. Apart from that, they also have the right to their privacy. And under this domain, I would say, under this domain, all the rights can be covered. Same, the publicity, personality, all the rights, I would say, broadly can be clubbed under the right to privacy itself. But when we talk about the personality rights can be understood through the concept of right to privacy of these individuals or these personalities. So a personality right basically refers to right of a person to protect her personality under the right to privacy. Now, what can that be? It can be their image, it can be their voice, it can be any sort of artistic expression that is unique to them. For instance, you do understand, I just gave you an example of Anil Kapoor. Now, Anil Kapoor has a trademark dialogue of Jackass, right? Apart from that, you do know Amitabh Bachchan has that unique voice, right? Amitabh Bachchan has unique voice. So people should not use that without the consent of these celebrities. Now, these rights are important because these celebrities, they are personalities who have great fan following, and people can misuse them for their own commercial gain through advertisement. For instance, say tomorrow I use one of these personalities photographs and tell them that they are promoting me, they are promoting Rahul sir. That would be illegal, right? Without their consent, if I try to promote the advertisements or something for my own commercial gain, it would be injustice with them, be it their photograph, their voices, or any specific trait connected with them. It is clubbed under right to privacy itself. Now the question comes up, sir, are there any definitions of these personality rights in our Indian statutes? Are personality rights recognized per se? And I would say the answer would be no. Yes, we have taught and passing off, but you do understand in India the tortious liability has been basically developed according to the law of torts of UK. That is the injuria sine damnum, damnum sine injuria. Both the concepts are applicable from UK. We use that concept. That means tortious liability for misuse of personality rights is available, especially if plaintiff's personality, that means the celebrity's personality, is exploited for monetary purposes. The classic example being, if I create an advertisement without the consent of the celebrity or the personality, they can file a tortious liability claim. This is one of the ideas available with us, right? Now, apart from that, no other law or statute classically defines these personality rights. Yes, to some extent, I would say whatever intellectual property rights that we have, under those, we can talk about trademarks and copyrights. To some extent, these are available with these celebrities. Again, the Trademark Act of India of 1999, it does not exclusively protect personal images or the personal rights. However, there are many celebrities who have actually created their own trademarks. For instance, there is Baba Ramdev. There are many actors, actresses who have created their own trademarks so that they cannot be misused by others. Yes. In fact, in one of the famous cases, Arun Jaitley versus the Network Solutions Private Limited, it has been highlighted that a person's popularity or reputation of a celebrity or a personality, it is no different in real world or on internet. That means on internet also these personal rights can be protected, or a trademark can be created on this. For instance, in 2011, one of the companies, this Network Solution Private Limited, what it did was it created a website by the name www.arunjaitley.com itself. And Arun Jaitley at that time had filed a complaint against this. So the court observed that an individual's personality rights, or the rights that they have, in reality and in internet, they do not differ. They have those rights there also. To some extent, I would say trademarks are recognized. Apart from that, under the Copyright Act 1957, content creators, singers, actors, musicians, etc., dancers, they do have moral rights. There are many provisions. For instance, the Section 57 of Indian Copyright Act, it does give recognition to personality rights or rights against copywriting it, right? So without the consent of the creator, one cannot use them. If there is any damage to their work, then liability can be claimed under the Copyrights Act. So to certain extent, I would say there are some provisions which are available in Indian legal statute under the tortious liability, yes, to some extent under trademark, but not defined per se. To some extent under copyright. That means under the intellectual property right regime, we do have some recognition of the personality rights or celebrity rights. Yes. But to a large extent, the rescuer here has been judiciary. That means if I am a celebrity, or if I am looking for my personality rights not to be violated, then I can directly go to the courts. And in many cases, the judiciary has come to the rescue. For instance, in a very famous case, in R. Rajgopal versus State of Tamil Nadu case, the court has highlighted that under Article 19, we have freedom of speech and expression, and this protects our personal rights or privacy rights as well. In fact, the courts have delved a little deeper, and they have suggested that right to privacy has two distinct aspects. One is a general notion. If somebody violates your right to privacy, you do have tortious action available there for damages, yes. And on the other side, there is a constitutional right also, that is right to privacy. Again, in this particular case, it was not clearly suggested that right to privacy, it becomes a part and parcel of our fundamental rights, but to some extent the ground was already laid. And you do know that in the Justice Puttaswamy case in 2017, the Supreme Court has categorically said that right to privacy of an individual is a part and parcel of Article 21, that is right to life and personal liberty. So right to privacy has now been recognized as a fundamental right, and a part of this right to privacy is also the personality rights or the celebrity rights. Apart from this, there are many cases where the judiciary has come to rescue. In one of the famous cases in 2015, in Shivaji Rao Gaikwad. Now, who is this Shivaji Rao Gaikwad? Shivaji Rao Gaikwad is Rajni Anna, that is the famous actor Rajnikant. That is, in Rajnikant versus Varsha Production 2015 case, the Madras High Court, it categorically said that in India, yes, we do not have any statute where the personality right is defined, but we have so many cases in which the personality rights have been recognized. And one of the classic ideas was the Titan Industries case. In Titan Industries versus Ram Kumar Jewellers 2011, it was clearly highlighted by the Delhi High Court that when a prominent person's name is exploited in advertising without their consent, the objection isn't that no one should commercialize them, rather it's that they should have power to decide when and how their identity is utilized. That means in this famous case, to a large extent, personality rights have been recognized. Now what happened here was, Titan Industries, they filed a case against Ramkumar Jewellers. Now this Titan Industries, they have so many brands, you do understand, they have jewelry brand, they have watch brand, etc. And they had basically taken the services of Amitabh Bachchan and Jaya Bachchan for promotion of Titan Diamonds. And that Titan Diamonds ad was actually copied by a local jeweler, and they used photograph of Amitabh Bachchan and Jaya Bachchan. And against that, the restraining order was passed. Apart from that, in Amitabh Bachchan versus Rajat Nagi case in 2022, this is one of the famous cases which has laid ground to the personality rights. In fact, in the right now in the Anil Kapoor case also, it was argued that in this particular case, Amitabh Bachchan versus Rajat Nagi case, the order of injunction was passed where no one can use actor's name, image, voice, or any of his characteristics without his permission. Now, what happened was, some people created app where they used voice, pictures, etc. of Amitabh Bachchan without his consent, and a restraining order or an order of injunction was passed against that. That means the judiciary has come to the rescue. It is the judiciary which has been defining these personality rights in India. In many famous cases, personality rights have been recognized. All right. Now, the question is, so do we need something else? Yes, absolutely. See, looking at the development that is taking place in recent times, the intellectual property rights system itself cannot protect the personality rights in totality. Yes, we have to some extent, we have trademarks, copyright, etc. But there is a need for more legal clarity, right? Personality rights, you do understand, they are sui generis. That means, their sui generis means, as the name of the person or as the name of the celebrity, it grows more and more, their personality rights, they automatically generate. And it is because of this reason, we are living in the age of information and communications technology, where every other day someone is going to become viral. That means a person is going to turn into a celebrity and their personality rights are going to evolve. Someone might misuse their images or use the videos that they have created from one platform onto another platform. So a lot of such things are happening. And that is why what we need is, we need to define the rules with respect to personality rights more clearly. Maybe there is a need to put them in a statute, or need for more clarity with the changing time, because we do understand that public personality and their popularity is ever increasing because of social media. Public awareness is also increasing, again because of social media. And in light of that, we need to have certain rules and regulations, or I would say at least guidelines, which need to be followed with respect to personality rights, or misuse or violation of personality rights has to be stopped. All right. Now, let's end our discussion by looking at some of the international experience. You must be thinking that, sir, okay, in India, you gave us example of the tortoise liability claim. Yes, you gave us example of trademark, copyright. Absolutely right. But what happens in other countries? For instance, in Australia, there is no concept of right of personality. Now, everything is covered under the tortoise liability. Law of passing off, basically law of torts. Under the law of torts itself, it is covered. Any sort of false association or false endorsement is actionable under the law of torts or the law of passing off in Australia. In Germany, personality rights are recognized. They are a part and parcel in the German civil code. They are a part in the German civil code itself. In US also, to a large extent, this happens. Again, in US, there is no federal law, but in United States of America, you do know there are 50 states, and different states have different laws for rights and recognitions of these celebrities and personalities. The law varies from state to state. In fact, some of the states, they have very strict personality rights, and some of the states that do not have personal rights at all. But in majority of the states in the United States of America, the personality rights are mostly covered under the different tort law itself. That means if something is misused, if the image, the voice, or any creation of the celebrity is misused, then they can claim they can claim compensation, or they can claim damages under the tortious liability. There have been many cases. There have been many instances, many cases in Hollywood as well, where people have gone to judiciaries, they have got restraining orders, injunctions, etc., against the misuse of their personality rights. All right. So what's the conclusion all in all is that we need a better or a clearly defined regime of personality rights going forward in India. Let's hope that happens soon. Whenever there is development on this, we'll talk about that again on Study IQ. But I hope that you have gained insight into what is the meaning of personality rights and some of the important case studies related to that. And the judiciary has been the protector of these personality rights to a large extent in India. With that note, let me end my discussion. Thank you for watching this video. Jai Hind.